My name's Richard McGregor. I'm the Washington Bureau Chief of the Financial Times. I used to be in Beijing for many years. I'd like to welcome you to the Penn Law Washington Seminar Series, which was created, so they tell me, to provide a forum in DC for some of the most pressing issues impacting the law, policy and society. Now, the issue tonight clearly is about America and China, the superpowers. We'll get to whether China is, of course, a superpower or not, and whether they're above the law. We'll be looking at when and why the US and China do and don't follow and support international law, and when the two superpowers' approaches to international law mean for the global order, including, of course, the international global order. Now, our ambition is to look at what their behaviour means for the role of rising powers on the world stage, as well as issues such as global security, trade, human rights and the environment. I think we'll be lucky in an hour to cover all that. But we've got a great panel who can guide us through some of those thickets. First of all, on my far right, Bill Burke-White, who since 2009 has served as a member of Secretary Hillary Clinton's policy planning staff at the State Department. He's on leave from Penn Law. Next, on my far left, that's coincidental, we have Professor Zhaojie, James Lee, a professor of law and the director of the Center for International Legal Studies and the director of the Center for Law of the Sea at Tsinghua University in Beijing. We also, on my immediate right, have Commander James Kraska, who serves as the Howard S. Levie Chair of Operational Law at the U.S. Naval War College in Newport, Rhode Island. And last but not least, we have Professor Jacques deLisle, who is the Stephen A. Cozen Professor of Law at Penn Law and the Director of the Center for East Asian Studies at Penn, and the Director of the Asia Program at the Foreign Policy Research Institute. So let's start with the issue of a superpower. Some of you would remember there was quite a well-known book written by an academic from San Diego, Susan Shirk, a number of years ago about China and the Chinese system called the Fragile Superpower. And quite famously, I think there were two reactions to this title. I think in the US, many people they said to her, "What do you mean fragile?" And of course, in China, they said the opposite. They said, "What do you mean superpower?" Which might reflect the way the two countries view each other. But just on that issue of, let's presume for the purposes of tonight's discussion that China is a superpower, even if it has yet to complete and launch its first aircraft carrier. I think that's coming soon. But let's presume for the purpose of tonight's talk that China is a superpower. And very briefly, I'll ask each of the panelists to just outline, what that means, the size, the impact, the power of these countries for the way each country views international law. And both panelists can talk about either country in doing that. Professor Lee, why don't we start with yourself? Describe for us how China, as a superpower or emerging superpower, approaches the issue of international law.
Well, since we cannot change the assumption, I think these days China is increasingly serious about international law. And a few years ago, in the party's 17th Congress, the General Secretary of the party, which is the ruling party in China, delivered a work report. It's sort of a state of party. So for the part of foreign relations, for the first time in the party's Congress work report, he said very clearly, so in the conduct of international relations, China should adhere to the Charter of United Nations, principles and rules of international law, and fundamental norms of international relations. So I think this set the tone.
That was 2007, right?
Yeah, I was in Hong Kong, because the report was quite lengthy.
Yeah.
Made me, very tired, and this mention to international really, wake me up. So, as international lawyer, I think, as quite a positive signal.
But China's legal institutions, domestic legal institutions, are evolving. It's yet another thing to put on top of that to have international law. I mean, ministries, the political leaders in the Politburo, do you think it's still a learning curve for them to handle international norms? Particularly as they've been constructed by the West?
They have. They have no other choice. Because when China opened up to the outside world, when China participated in international relations on all dimensions, they just found out that the world, the international community they were joining in had already been well regulated. So you have to be familiar with the rules of the game. You have to play the rules of the game. Otherwise, there was no way for you to communicate, for you to trade, for you to conduct relations with other nations, particularly these Western law-minded countries.
Okay, last quick question. Of course, there's many people would say there's the international community, then there's the U.S. And people might say that the U.S. considers itself is bound by international law when it suits it, and it isn't when it isn't. I mean, is that the view in China? Are they that cynical about it?
I don't think I'm the right person to say that. But one thing I can tell is that China, a country like China, certainly does not enjoy the luxury of, as United States does, of occasionally violating rules of international law. As this gentleman just said a moment ago, the stake is too much. The cost is too much.
Well, does the U.S. enjoy the luxury of violating international law? I mean, you can give us a bird's eye view of that and the U.S. view of it.
The luxury of violating international law. Well, I mean, one of the paradoxes of international law is why any state that has the ability to avoid it would obey it, right? And so, everybody likes to quote Thucydides, the strong do what they wish, the weak suffer what they must, and so why would you bind yourself by rules? And that coexists with Lou Henkin's famous observation that most states observe most international law most of the time, and why would they do that? For the U.S. in the post-war period, it made a fair amount of sense because it was largely an American-constructed, or at least American norm-consistent, international legal order. Relatively liberal trading regime, security regime which sought to maintain peace and stability in a relatively status quo way, but had a pretty big exception for invited intervention or collective self-defense. And that had a human rights regime that favored civil and political rights over economic and social rights, and they were both in there, but the ones that had more operative content, a lot of the instruments. And so it was, the hegemon gets to sort of make the rules and gets benefits from them and follows them sometimes. But,
is that still the case?
I think it is still the case for now, and one of the questions about the rise of China is whether we're going to see another player with a different view. I mean, it's not as if there's a uniform Western view. The Americans and the Europeans have very different views on a lot of international law issues. And I don't think the U.S. is any different from China or other states in that there are certain interests which are considered more important than being law-abiding, and mere violation doesn't throw everything out. But it seems to me, in terms of this question of China's rise as a possible superpower, we are seeing at least China's emergence from being at the opposite end of the spectrum. That is, the story of the reform era and China's beginning to engage with international law was trying to join the system on its own terms. It really did accept the rules that were brought to it. So it signed on to the WTO with all sorts of concessions about changing its own economy to come into line with WTO GATT-based norms, which were largely post-war liberal market creations. It accepted the universality of human rights, even though it thinks they're instantiated differently in different contexts. It moved toward accepting a Security Council-centered international law regime for the use of force and so on. So it was basically a regime taker in almost every sense. What we're seeing now in the last few years as China has become more powerful and more self-confident is some interesting shifts that make it at least look a bit more like what one would expect of a superpower dealing in international law. So what had been a very, very strong notion of sovereignty, it is completely improper for other states, for State A to intervene in State B's domestic affairs, to try to change State B's domestic order, certainly through force. Humanitarian intervention in Kosovo, completely off the table in the Chinese view. And lots of imperialist interventions by the US and by the Soviets back in the day when the Soviets and the Chinese weren't getting along. China pushed very hard against that and wanted at the very least Security Council authorization, and even then was fairly skeptical. That was a very hard line. On human rights, it was a rejection of universality and a brief flirtation with the Asian values argument, that things were different. We've really seen movement on all of these areas. So if you look at the sovereignty side, it's remarkable that China has now acquiesced, abstained in the Libya resolution recently, and before that has supported a number of uses of force. I think the two most striking recent examples are the abstention in the Libya case and the sending of the Chinese Navy to deal with pirates off the coast of Somalia. Now, these are done in ways that China could always appreciate through UN Security Council processes and all of that, but it really is a remarkable move toward the notion that under some circumstances, it's appropriate to use force inside another country, including for circumstances that are not narrowly limited to self-defense. You look at the trade regime, China signed on the WTO, made all these changes to conform. Now we're starting to see China say, hey, how about some regional trade agreements that are outside the core WTO framework, governed by it, but they have their own characteristics, and they're Chinese-style arrangements. They serve Chinese political interests. And on human rights, we've gone from a flirtation with Asian values to a much more assertive discussion that there's a Chinese model that is not Western-style democracy, that is not separation of powers. Just ask the Oshawa how that's going. And so we really do see the beginnings of an articulation of a distinctive view, which is the kind of thing you associate with superpowers in international law. They have their own view and they push it. We're at a very early stage, but I think we're seeing some signs.
Let me go to you, Commander Kraska. I think you've actually negotiated with the Chinese on these issues. I mean, do you think there's a distinctive Chinese view emerging, or is it really, managing the issue purely for what their political objectives are?
I would suggest that it's the latter, actually. The way I would view the Chinese is that they're very much sort of pre-Wilsonian United States perspective. And I would suggest that in the U.S., really it's Wilson that, although he was unsuccessful in obtaining the League of Nations, was successful in shaping or coloring every administration, both Democratic and Republican, since then, up including George W. Bush and President Obama. And it's this idea of refashioning the world. I mean, Wilson said, make the world safe for democracy. And I would suggest that every president, you can find FDR, JFK, Johnson, Nixon, all of them.
As of this week, President Obama as well?
President Obama, absolutely. All trying to shape the international order, certainly in America's interest, but with the idea that what's in America's interest is in the global interest. It's kind of like what's good for General Motors is good for the United States. And I would suggest that China is not at that stage. It doesn't, it's much more of in sort of a Teddy Roosevelt view, I think, of international law and diplomacy, which is establishing itself in its, what it considers its area in the Pacific area of responsibility, so to speak. And it remains to be seen whether China adopts this, something that's really a Anglo-Saxon American view that there's a national interest in world order rather than just a pure pursuit of a single national interest. That is, that the nation benefits because there is a global order. And really it was the Dutch, the United Provinces, I would suggest that first adopted this perspective, and they were going against the very sort of doctrinaire Iberian powers of Spain and Portugal, Castile and Portugal. And then it moved from there, from the continent, to the British and the French, unfolded over 200 years, and then it moved again when the United States assumed the baton, in the 20th century. So it remains to be seen whether China can sort of look beyond its very internal periphery and have a global perspective, and what that perspective will be.
That's interesting. Bill, I think you're the only person I haven't given a title, if you don't mind it. Yes, I mean, you were at Penn Law, now you're in the State Department. having, I don't know whether you were there before, but I mean, once you're inside the State Department, have you got a different appreciation for how the US approaches these issues?
So I want to start by looking at the broader context in which some of the changes we're talking about have happened. I mean, international law itself was, as you rightly mentioned, a kind of transatlantic project largely of the last 100 years, but certainly going back before that. What we have seen, I think, is a series of emerging powers beyond just China, ranging from India to Brazil, where President Obama was this past weekend, to South Africa, Nigeria, and others. And that those countries are coming to play a much larger role in the international legal system than they ever did before.
So it's not just China.
So it's not just China. And as we look out at international law from within the administration, I think the first approach we take is a functionalist one, which is to say, what's the challenge? How do we go about solving it? And what role can international law play in doing that? In some cases, we and the Chinese see eye to eye, and we do with the Indians and others as well. But on other issues, there are really fundamentally different interests at stake. And that makes international rulemaking, not to get to the question of compliance, much, much harder than it ever was. It used to be, if the US and Europe were aligned, you had an international legal rule and you were done. Today, you have to take into account a vastly larger number of interests that have a much greater weight in the international legal system than they ever did before. So I think that's the backdrop against which we're operating. It means that international treaty making is much, much harder, particularly on a multilateral level, than it has ever been. That doesn't mean one doesn't stay committed to international law, where the creation of new legal rules can further the interests that we share with other countries, whether that be in climate change or humanitarian intervention. In terms of the question, I think where you were getting at is one of compliance, and when do you sort of comply with international legal rules. I think the events of the last week show more than ever how powerful international law can be in helping achieve our interests. I think if you roll the clock back 1 week from today, who would have thought there would be a Security Council resolution, 1973, authorizing the use of force to protect civilians in Libya, and that there would have been a collective effort within the framework of international law to do so? That was a week ago. So quite extraordinary commitment to using international law, to working within the confines of international law. It's not easy. Building that international consensus today takes extraordinarily hard diplomacy, both in New York, where Ambassador Rice worked on this tirelessly, and back in capitals. It requires us to work with all of those rising powers and other partners to make sure everyone's on board. But when you have those pieces line up, the outcome can be truly extraordinary. So I hope what we're seeing at the moment is not just a new commitment to international law itself, but a new recognition of how powerful a tool it can be when we actually use it.
One point that was made there, Professor Lee, was that China initially was a regime taker or a rule taker. I mean, you joined these institutions and you basically signed up by and large to what they were. Obviously with the WTO, that's been a fantastic success for China. But what about, is there an evolving approach now that you want to influence and change these institutions governed by international law or international law itself? And if so, in what fashion?
Well, this is first of all, a matter of perception. How international is perceived by a country like China, by Chinese government officials. By and large, I think international is still perceived as a sort of an instrument, to regulate relations, mainly between or among sovereign states. From that perspective, China these days are really making efforts to participate, to get involved in this process of lawmaking. However, this is also for China a matter of institutional capacity building. We have to recognize that international law originated from the West. Used to be Eurocentric law of nations for quite a long time. So and China, was the underdog, victimized by this Eurocentric international law for more than like 100 years, ever since the Opium War of 1842. So when I talk about the institutional capacity building, the first started with trust. Should China trust Western-oriented rules of law, governing relationship between among nations? By and large, I think to make a long story for short, today China does feel that it is a beneficiary of the present international legal order. Now, I quite agree that after the Cold War, we witnessed this sort of quantitative and qualitative change of international law. China are making efforts to involve itself, to participate in this process of lawmaking. However, as this gentleman just said, Bill said that these days, negotiation of multi-treaties, multilateral treaties are becoming more and more difficult because we have sort of new partners, new.
Well, that's right. That point. I don't know whether the point that Bill made, that this is not just G2, which can be not just a binary thing. It's
right.
Brazil, South Africa, India, all with their growing quickly their interests of their own. Do any of the panelists see them as potential or becoming allies of China in this at all?
I think it depends on what issue areas you're talking about. I mean, one of the things I think that has held back a greater Chinese influence in shaping trade rules is that China's interests align complexly with those of a lot of other developing countries. In some ways, they're much more aligned with the US. I think on agricultural subsidies and things like that. China is different from the other emerging powers in that it, for now at least, is the big target. It's the one that's highly visible to the rest. So there's a sense if China becomes very assertive in many of these contexts, it's going to get blowback in a way that other emerging powers are not. So people do talk about the BRICS, and there is a coherence to that, but really there's a sense in which China is the more visible entity, and therefore takes bigger hits, I think, for pressing an agenda. And there are all sorts of obvious reasons for that, having to do with size of the economy and with the more adversarial, or at least less non-adversarial security relationship with the US. And I think it's also something to get to what James was just talking about. There is a wariness of Western legal institutions that is rooted in a bitter 19th century experience. And so there's a certain skepticism with which they're greeted to this day, and a certain view that the West was willing to use those legal rules in a highly instrumental and sometimes abusive way toward China. And so, these are tools that can be wielded in a variety of directions, and I think there's a deep appreciation for that. And I think it also, here international law bears a shadow of foreign policy in general. Deng Xiaoping famously gave the foreign policy dictum, nourish obscurity, hide your brightness, don't make it too obvious that you're becoming powerful, bide your time.
Too late for that, I think, for
China.
sure.
But that was tried for a long time and it does linger. And of course there was a second part of Deng's couplet. It wasn't just Tao Guang Yang sort of nourish obscurity, it was also accomplish something. And I think what we're seeing now is China is at the cusp of realizing obscurity is past. And the question is now, how do you accomplish something in a way that serves your interests but doesn't provoke pushback? And that's a very new experience, and I think there's a real sort of groping toward that. And that's why we see some half-starts and some ambivalence on getting into trying to shape trade rules, on how far to go in backing away from the very strong sovereignty notion, a feature, by the way, that they share with the US in approaches to international law, a distrust of letting international law come deeply into domestic regimes.
And they don't even have Congress to enforce it either. But on the issue, some issues where there is obviously a clear disagreement, the Chinese interpretation of the economic exclusion, the EEZ. Now, without litigating that entirely, I mean, could you explain that for us and how you interpret the Chinese position? And Professor Lee, you can talk about that later if you want.
Absolutely. I would also, though, like to follow up with something Bill suggested, and that is the Security Council resolution with regard to Libya. To me, it highlights that not only is China in the position I described, but so is Russia. And you have these two nations that are most likely the most powerful nations after the United States, and lauded for not standing in the way of world order. I mean, think about that. Not participating, not picking up a shovel and going to work with the international community, but just thank God they didn't stand in the way as they have in the past so many times. And so I think that's sort of where we are with these, with many of these BRICS, is that they want to have a voice, and yet there's responsibilities that that have to be met. Of course, it's a rational decision, because if you can get, it's Tom Sawyer, if you can get your friends to paint the fence for you, then why not? And the United States can borrow the money from China in order to make the world safe for China's rise, which is essentially what's happening. But with regard to the law of the sea, I think that it's and the exclusive economic zone, that's the fishery zone, the natural resource and fishery zone that goes from the baseline or the low water mark out to 200 miles beyond the coast. And so the United States and China have had differing views on what is the state's competence, the coastal state's competence in that area. And as a result, it has caused a number of incidents, both in the air and on the oceans, and actually under the water as well, where Chinese vessels have intercepted U.S. aircraft and U.S. ships in this area. Now, this is not a new disagreement between China and the United States. What's new is that China has a newly acquired capability. I'm talking about military hardware assets as a result of the expansion of the economy over the last 2 or 3 decades, and double-digit defense budget increases. China actually has the capability to know that the U.S. Navy is operating there. Previously, they probably had no idea. And then they have ships and aircraft to actually go out and intercept. The disagreement comes down to the interpretation of the exclusive economic zone, where China suggests that the state has some sort of military equity or military interest in this zone. And all of these issues were discussed from 1973 to 1982 during the Third UN Conference on the Law of the Sea. And China at that time, along with a handful of other countries, proposed on several occasions that the coastal state ought to have some sort of national security competence in the area, and that view was rejected. Well, the issue was dormant from 1982 with the adoption of the Law of the Sea Convention until the late 1990s, when China started to act on its view that had been rejected by the conference.
So, Professor Lee, is that a fair summation?
Well, first of all, I have to confess I'm not a law of sea expert, but I'm very interested in this subject matter. I think to put a long story, make a long story for short, the basic disagreement between China and the United States in regard to the legal status of EEZ is that we think that the sort of all the activities conducted in EEZ must be in conformity with these general principles of the as reflected in the 1982 Law of the Sea UN Convention on the Law of the Sea, which is you must respect when you conduct activities in coastal countries, EEZ, the security, territorial integrity, sovereignty, and China's argument is that okay, now these activities to be conducted in EEZ, which has sort of relevance to the legal questions that exploration of natural resources, conduct of scientific activities. These two big categories of activities have been placed under the coastal state's jurisdiction. In other words, as a coastal state, you have you sort of your sovereignty, your exercise of sovereignty reach to that part. So now the argument of the United States is that this part of water is international water. So the United States has all kinds of rights to do all kinds of activities. China do not agree with this kind of categorization. So always I heard the argument. Okay, now the U.S. Navy boat sort of did something within the Chinese EEZ. What's the nature of this kind of activities? Scientific, survey, research?
Well, I don't think so.
So this is a sort of where to put technically the disagreement between two countries lies.
Yeah. So I don't know whether we should get too obsessed with this issue, but I wonder whether this is a classic case where this is a political question for a country, in this case China, which obviously runs up against what the US in this case regards as a settled tenet of international law. I mean, for the Chinese, I don't think they could abide having US ships for whatever reason just off their coast.
Can I just put two more sentences? Well, another argument of I heard from the U.S. Government is that okay, you Chinese can also send your Navy fleet to our EEZ, doing the same thing. Well, first of all, China at present does not have the capacity of power projection. Second of all, China won't do that. China won't do that with this kind of cultural assumption that we have a saying in Chinese: "Do not impose others what you don't want to do to yourself."
If I could, I think that actually is something that I've thought about on this issue, and that is that some Chinese scholars will actually say that legally the United States is correct as a matter of law. In fact, China voluntarily joined the UN Convention on the Law of the Sea, knowing that it had not prevailed in these negotiations and it didn't get its way on these issues. The Law of the Sea is a package deal, and so China said, well, all countries have to either accept or reject the package deal, and China has accepted it, therefore they have an international law obligation to comply even with the parts that they didn't favor during the negotiations. But what's interesting, I think, is that it highlights that with China there's sort of whereas the United States approach is very legalistic and black letter, the Chinese approach is much more of it may be lawful, but it's just not nice. It's rude, and it's akin to a peeping Tom looking in your window, walking along the sidewalk. There's nothing in the law that says that you can't look in somebody's window as you're walking along the sidewalk, which is what the United States is, the proverbial sidewalk. And by the way, this is beyond 12 miles off the coast, only beyond 12 miles off the coast. But it's just not nice, and your neighbor doesn't like it. And so I think that it sort of gets to a difference of what order ought to look like, what global order ought to look like.
Any comment on that?
I think that this gets to a couple of interesting points. One is that recognizing the textual issue with the EEZ and that China's on relatively weak ground there, some of the Chinese arguments against the U.S. presence there have taken the form of a more abstract set of principles about due regard for the interests, sovereignty, and security of the coastal states. That argument was lost in defining EEZ, but as a sort of background international legal norm of peace, security, and stability, it gets invoked almost on a parallel track. The other thing is that the locus of some of the conflict has now shifted to, with China having greater capabilities, the shadowing of U.S. ships. The collision, of course, with the EP-3 spy plane, the reconnaissance plane, on April Fool's Day, unfortunately enough, back in 2001, was the most dramatic incident. We've had several of these incidents of shadowings, and so now, in a sense, the legal issues have added to them has been this notion of the rules of the road and whether China is transgressing those and behaving maybe lawfully, maybe not lawfully, but certainly rudely. But I think Professor Kraska is absolutely right that there is this invocation of of a broader norm of niceness. It's not this on-off switch. It's more of a slope of good behavior to illegal behavior with things in between. And you see this in the dusting off as a central tenet of Chinese foreign policy discussions spilling over into international law of the good old 5 principles of peaceful coexistence. It was an old sort of Mao-era doctrine about solidarity among oppressed states and why we should all get along, the sort of Rodney King principle of international law, if you will. And that has really come back to the fore largely to underpin these kinds of arguments.
But Bill, you were talking earlier about the Security Council resolution late last week. Of course, during the second Iraq War under George W. Bush, there was a great debate, as people in this room would know far better than I, about whether the US needed to go to the Security Council at all for the use of force. So, I mean, institutionally, the State Department might have a view, but of course, you don't run the country. I mean, does the US view on international law wax and wane as well and change with presidents and administrations? And is that make it harder then to sell it as a package to the international community when the US's public view itself is so often at odds with each other?
I would certainly say you see a very different approach toward international law in this administration than you may have in some past administrations. For us, it is one of the first things that one thinks about when asking how do we solve a problem. And certainly it was the first thing that we did when we looked at the Libya problem and said, how do we solve that? There was no question, as far as I could tell, in this president or this secretary's mind, that you wouldn't start at the United Nations. And we had the right partners with whom we'd worked hard to be able to develop the relationships that got us the resolution that it was actually led in many ways by the Brits and the French to get that resolution, but it wouldn't have happened without us at the table. That is not necessarily the way the United States always approaches a problem. Sometimes when you haven't done the hard work to build the relationships, you won't be able to get the outcome that you need. It's one of the reasons that President Obama has talked about when he was in India and again when he was in Brazil this week, the need to modernize those institutions to reflect the global order that we are building today, the just and sustainable international order, as he put it in the national security strategy. So a big commitment in that direction makes it much easier for us when we go out to a country like China or Russia and say, here's the challenge, how do we solve it collectively? When you don't invest in those, in building those relationships and restructuring those institutions, it's much harder to then go and sell it when you need it. So I think, we talked about law being a package deal. In many ways it is. For a country to be able to use the law when the law is available to help them, they have to be committed to it throughout. So I think you've seen a different course. I think it's also, though, a course that is both based on values, an administration that really says this is a core value, but also one based on interests, to say that in a world in which you have emerging powers that don't always share your interests, you're much better off building strong institutions that can constrain and shape discourse and lead to outcomes that are kind of mutually acceptable. You're much better off doing that than not doing so. And I think as you look forward, the era in which the United States could simply decide what the rules were is probably over. And it is an era in which we work with a range of different partners to build the consensus one needs, hopefully within a legal construct, sometimes not illegal, but outside of a formal legal institution. But I think you will see a United States that looks at that world very differently when you have emerging powers and real global challenges that desperately need solutions.
Is that because the U.S. power relatively is waning? Is that why that's happening? I mean, to be crude about it.
Lawyers tend to think of law as doing a variety of things. Lay people do too. The first instinct is to say it constrains, right? And much of the debate about do superpowers care about international law, is the U.S. above the law, is China above the law, is about how those who can flout the law can get away with it, and it fails to constrain. And on that score, there are some genuine weaknesses, but law is also, of course, an enabling device, right? And it provides ways of cooperating. And I think we're probably seeing some of that. And to the extent that the U.S. needs cooperation, which increasingly it does to deal with these kinds of activities, both because of the the scale of the demands and because of a desire to avoid resistance, these institutions have their utility. And one of the things, I mean, that works particularly in the Chinese context is China has invested a great deal in saying the proper way to handle international security threats is through the UN Security Council, or sometimes through regional security arrangements, and through multilateralism and such. And so, in a way, that kind of commitment, which has been made very loudly and for a very long time, it's a way of constraining China's defection from that regime, right? If you're willing to go through those channels, then China's put in the uncomfortable position of standing in the way of a Libya resolution. Whereas if the U.S. goes off and does it on its own, China can sit on the sidelines as it did with Iraq too. The Iraq can just say this is a completely lawless act. So these institutions do have that sort of mobilizing and sometimes constraining virtue in that sense.
May I suggest, I obviously I speak in my personal capacity, even though I'm an active duty officer, but I'm not sure that there's a difference in rhetoric with the administration now versus recent administrations, in particular the Bush, but I don't see a large difference in substance. And what I would suggest is that there's something that is Wilsonian about America. That's true, and it's both bipartisan. And I think that somebody like George W. Bush is driven by spreading those ideals. Okay. On the other hand, there's also a skepticism of international law that I think is sort of deeply American. And the two that I always think of are Daniel Patrick Moynihan and Jeane Kirkpatrick. That they're basically of the same position with regard to the UN, and yet they're from different parties. And when you look at American power after World War II, it's always been dependent upon building coalitions. Think of President Reagan and the ground-launched cruise missiles and the cruise missiles and the ballistic missiles in Europe. All of that was about Reagan engaging with the Europeans to get them and keep them on board despite huge protests, 300,000, 500,000 people in some of these capitals. That was all coalition building. I see President Obama increasing the drone strikes in Pakistan from the Bush administration, finally sort of suggesting that there's really no other option except maintaining Guantanamo Bay. There's no change there. There's an increase in troops in Afghanistan. There's no difference in Iraq. You see that both the Iraqi war and the Afghanistan war were both authorized by Congress and large bipartisan margins for the authorization for the use of military force. So there is obviously, you don't have sort of the Texas, we're going to kick ass type of rhetoric, but substantively, I don't see a change, and I don't think that's bad. I'm actually comforted as an American from that.
So last week's resolution remains the exception, not the rule.
Well, I mean, last week's resolution was Libya the United Kingdom and France not wanting to do it without the United States. So that's kind of a freebie. I mean, that's a give me because they came to us. I mean, they wanted it more than we did, and it was, in fact, we'll see how it plays out. I mean, from the media, it suggests that the administration was sort of more skeptical about starting now getting involved in a third type of military operation. So I don't know how difficult that is to sort of authorize and then provide logistics for an operation that two allies are seeking. I just don't see a large difference. I mean, I think that we have these sort of the skepticism as well as this Wilsonian impulse, but I think that it's fairly bipartisan. I mean, look at President Obama. I just don't see much difference.
Any comment on that?
Sure, I would suggest, and I actually am appearing in my official capacity, so I obviously am speaking in that context. But I do think that there is a remarkable difference. If you look at, first of all, the way one addresses a problem, and I have not served in an administration prior to this, so I don't know what their initial question is. Our initial question is often one of, where is the law on this? And how do you work within the law on it? And what are the choices you have within that legal construct? Obviously, we, in the past week, have been in a position where we did not have to contemplate operating outside of the law because we were able to use the institutions to get there. The commitment to the law is what in many ways allowed us to be part of a structure that led to Resolution 1970 and then 1973 and got one there. So yes, I can't tell you the counterfactual of what would happen if that hadn't happened and so forth. But the other examples that you mentioned, for example, Afghanistan and Iraq, Afghanistan was, in fact, within the construct of Article 51 self-defense and with the permission of the United Nations Security Council. Operations in Iraq are now conducted with invitation and permission of a legitimate Iraqi government. So on those fronts, again, it's not the administration saying we're going to violate the law, violate international law in some way.
Both predate the election of Obama.
Right, but you were suggesting that our continued presence in those conflicts might somehow suggest we were operating. But to me, I think the fundamental question is, what is the way you approach a problem? And I think there is a remarkable difference in how the administration thinks about those issues.
I think it's the case that, as you're saying about freebies, I mean, some of these cases of getting authorization or not getting authorization for use of force, everybody would at least rather have the law. I mean, there are certain sort of extreme folks who want to poke enough of a thumb in the eye that they'll revel in the lack of legal authorization. But some of these are easier cases than others. So Afghanistan, leaving the political sympathy for the United States, which was huge at the time, aside, it was an attack based in one sovereign state by an entity entangled with the government on the territory of another sovereign state. Classic case for use of force in self-defense. No way the UN would not follow that one unless it were profoundly broken, which it has been at times in its history, but was not at that moment. Gulf War I, very much the same thing. One state invaded another state, tried to obliterate it. That's the easy pushback. The tougher ones become things like Somali piracy, especially if you're chasing the pirates into the 12-mile limit and onto dry land, or humanitarian intervention type notions, or Kosovo, where NATO is acting outside NATO spheres. And so the tough tests come in those cases where it's not a slam dunk easy yes or a completely unreachable no, but where you are determined out of matter of interest to do it. What I would say is, the Wilsonian strain is there in American foreign policy. It does run administration to administration, you're quite right, but it coexists with a deeply schizophrenic other strand, which thinks Wilson was an idiot, right, and that it's all about national interest.
I think Glenn Beck thinks he's a criminal or something.
Well, right.
Even worse,
well, I wouldn't. One doesn't go as far as criminal, but our Penn colleague Walter McDougall has a book called Promised Land, Crusader State, which I think sets out to capture this idea that there's a global meliorist notion of making the world a better place, making it safe for people and certain ideas, and that's an enduring feature of American foreign policy. So too is the notion of essentially we've got interests, we'll go out and protect those interests, but getting beyond that is folly and possibly self-destructive. Walter has his views on which of those is better, as most of us do. But I think the point is they're both enduring tropes, and they have really complicated implications for international law. But either one of those can lead you, depending on the circumstances, into making significant use of and taking seriously international law, and other times to saying it's just got to be overridden because something else, be it national interest or an agenda of transformation, is simply more important.
Okay, so we're going to go to questions now. If anybody's got any questions over there. Microphone's coming.
I'm Lenny Shambon, class of 72. Most of my professors are dead. I don't recognize any of you. Let's go back to the theme of whether or not superpowers, the United States and possibly China, are above the law. My area of expertise is the trade area. The United States took 17 years to comply with the Mexican truck decisions it made in NAFTA a long time ago. China last week won a very big case in the WTO about the application of countervailing duties and anti-dumping duties simultaneously to a non-market economy country. Is there an inevitable theme in international law of big countries, big people, will always foot drag in adhering to decisions against their interests?
Sort of touched. Anybody want to add to that? I mean, you touched on it before.
I would suggest that all countries will foot drag in international law, not large countries or small countries.
But can superpowers get away with
The
it
bigger
for
your
longer?
feet, the harder you are to drag. I mean, that's certainly true.
Yeah. Anybody
Well,
else? Yeah, please.
I agree. This is sort of a question probably in a different context. What is international for? As a matter of bloody reality, international today is mainly for powers, powerful states. I think whether it's the United States or China or India or South Africa, if they see that application of rule of international law, is sort of absolutely against their national interest, well, you see this either violation or resistance. It's, the pattern is so similar.
Okay, another question. Anybody?
No, but
oh, sorry.
One thing I would say, to that extent, much depends on how do you see international law. As I talked to Bill or you in the corridor, today we have to say most rules of international law are still self-interpreted international law. Large depends on do you have the power, hard or soft, to make the interpretation in your favor. Okay.
Any other questions? Here we go. There.
I'm not an alumni of Penn State. I'm Sabine Muscat, the Washington correspondent for Financial Times Deutschland. Hello. And I'd like to go back to that question once more about the title of this event and about the superpowers above the law. And looking at the justifications with which the US and China are not adhering or refuse to accept some international rules once in a while, I mean, they've been very different. China, as we have heard, is usually saying we're too weak, we are a developing country, we have these principles of non-interference, and we are simply too weak to do what you want us to do, whereas the United States would have come from the position of either we make the rules or we break them maybe in some ways and at some periods, and we're the superpower, and we'll get it done if nobody else wants to jump in and wants to join us. So I'm wondering whether, do any of you see a point in the future where China will shift its justification to now we're a superpower and now we're actually basically going from the pre-Wilsonian to the post-Wilsonian phase, if you want, or whether the United States may shift the other direction, as we've seen in international climate negotiations, where the US is suddenly saying, well, we're too weak, and Congress might not accept this if we enter this binding agreement. Or will they converge at some point and both be fragile superpowers in the future? So that would be something that I would like to hear from you. Thank you.
Anyone want to have a go at that?
I mean, the Chinese, well, first of all, it is one of the striking things about international law, and you can either think of this as a strength of international law and a vindication of the notion that states try to comply, or if you're cynical, you can think of it as showing the utter vacuity of international law, which is states almost never say they're violating international law. I mean, the sort of decentralized judgment and interpretation thing is the name of the game. So, to take the relatively extreme examples, in the second Iraq War, there was a claim that there's a notion of preemptive self-defense, right? And that stirred up a lot of dust. But the claim was this is within the scope of at least plausible legality. Humanitarian intervention, another one, which is reform. There's a fair amount of lawmaking that occurs through law stretching and occasionally even law breaking. And on the Chinese side, there was long a claim that human rights were completely off the table because it was a domestic sovereign realm. So why does China push back against it? Some of it is we're too weak to bear responsibilities. So you're talking about living up to international norms. That's absolutely part of it. Can't fully come into WTO compliance, can't fully come into climate compliance because of developing country status, all these problems. But one doesn't want to leave out of that mix the other Chinese argument, which is this is none of your fricking business. I mean, this is an internal sovereign matter. Nobody else should muck around in it. I think, that's not a statement of weakness. That's actually a statement partly tied to weakness, but also partly tied to strength. And the U.S. has had some similar views. I mean, from the U.S. and Chinese view, the Europeans are the weird ones here. I mean, why do you want to create all these international tribunals and rules that can muck around in your domestic order. That's just a bad thing. I think the question, as I sort of said in some of my opening remarks, China is clearly moving away from the position that cannot be associated with a superpower. The regime making minimal excuses around the edges for not quite living up to things. That is the argument of a weak state. But what you are seeing now is China exiting that. We don't know where they're going yet. I think China is a long, long ways from doing what either the United States or the Soviet Union in its day did, which is saying this is how the world should be. We have an image, we have a vision, you should go out and do that. We're seeing little bits and pieces of it. But it is done at the moment in a more eclectic, pluralist way. Everybody may have their own way of doing things, this is ours, but it's getting a little more assertive. Think of the Chinese analysis of the global economic crisis, the global financial crisis. When Zhaojie came to town and didn't say, well, there's a Chinese-style economy and there's an Anglo-American capitalist economy. He goes, you guys are running a casino and you darn near trashed the international economic system, and by the way, all those T-bills we own. So there is a sense of there's a better and different way of doing it. Human rights, there's long been an argument that social and economic rights precede civil and political rights, and that they are only achieved through a capable state, and that therefore the state restraining Western view is wrong. So we do see these pockets here, but I think there is a lack of vision as yet about what a Chinese approach might be, and that there is a deep skepticism in China about whether it is wise to push a Chinese model, either because it will generate pushback by being so assertive, or because it will generate concern about whether China has an expansive agenda, and it may fail. I mean, one of the other concerns is the not-so-rising powers, the African countries that look to the Chinese model, perhaps. What if they try it and it doesn't work? Does China get blamed just as the Washington Consensus gets blamed for instantiating a certain approach to property rights and law and such in countries that then ran into severe financial crises? So there's a real, so you say Chinese, if you want to drive a Chinese think tank person to distraction, you say, how about the Chinese model? It's like, no, there's no Chinese model.
Well, let's is there a Chinese model?
Well, no. Nor Premier, answered that question, in a very sort of, clear manner a few days ago when he was asked by a French journalist. By and large, I think we Chinese are still in the process of groping. It's very sort of challenging because we have a very huge historical burden to sort of to carry on. But it's very difficult ever since China was forced open more than 150 years ago. Something in our historical heritage turned out to be outmoded. Something are still sort of working. So this grouping process, got to be a long process. And also, on the other hand, the Chinese has the whole Chinese people, including the decision makers, have quite understood that the present model, economic, social, political, or the present system, institutional arrangements are not sustainable. My last trip to Washington was 1994 as a student. Right now, thank you, Professor deLisle, to bring me back to United States. I have a very, sort of, a special feeling, about, the economy. See, in China, we sort of, people say China is a world factory. We pay very high cost, we sort of, pollute our environment. We sort of, exhaust our resources to push this, export-oriented economy. Well, what we got? Paper notes of American dollars. What you got? Real substance. Yeah. Even you have, you buy things with cheaper price than the price in Beijing these days. So this kind of model, first of all, it's not model, but this kind of economy is certainly not sustainable. We have to change. So the structure, has to be restructured.
That's a whole other debate, that one. The, yeah.
Thank you. Yeah, I'm Brian Yao. I'm a lawyer from Dutch law firm in Guangzhou, and I'm a visiting scholar at Columbia Law School. My question is like this. A couple of days earlier, the Chinese National Congress leader Wu Bangguo said, "We Chinese already established legal system with Chinese characteristics. Does that mean there is no space for China to reform its legal system?" Thank you for your answer.
Yes, I think Wu Bangguo said more than that, didn't he? He said, keep away from the separation of powers,
It's a rule out.
No, Wu Bangguo said it again this year, I think.
Right.
Anyway, one leader always says it every year. Yes.
I think that's a tick the box remark, frankly. I mean,
it's a big box.
It's a big, right. I mean, I think that is code for kind of the legislative drafting process. And so, many years ago, sort of been a rolling target, but the idea was to have a complete legal system, you need to have laws governing the following areas, right? And what we've seen in the last few years is filling in the last of those pieces in terms of basic statutes. The tort law is the most recent one. On the international side, the law on conflict of laws, what happens where you have two laws potentially governing. And so it is a fair statement to say that almost all that framework is in place. I don't think anybody, including Wu Bangguo's speechwriters, think that the project is done, that there isn't a lot to do. And one of the interesting questions from the perspective of this panel is how much will China continue to bring into its ongoing legal reform international law norms or borrowed foreign norms? That's been a big part of the story. It's going to continue to be a big part of the story, but part of the pushback against separation of powers and such is saying, look, there are limits, and there are going to be things that are going to suit national interests that may be different.
But isn't the question with law in China and also international law, China adopted this because it works. They look at successful, rich Western countries, they have a legal system, they say, well, we'll have that. So it's utilitarian. Or do they have it because they believe in it? Because it's a good thing, because it's a good thing.
You Cooking wrote an essay called "Democracy is a Good Thing." Anyway, see, the law is a good thing. But yeah, I think Bill Burke-White was absolutely spot on this, which is nobody sits around saying, how can we make a better law? They say, how can we solve serious problems which are facing China? Problems of attracting foreign investment, which is now been done well enough that that's not such a big concern, but problems of maintaining social stability, sustaining growth, dealing with inequality and its fallout, unrest, all that sort of stuff. And they look around and they do what Professor Burke-White does and say, okay, well, law may be part of the solution. Let's put that in the mix.
Anybody else or any other questions?
Well, I have two observations on this question. First of all, from international legal perspective, well, you see this pattern. The more concrete, more precise the rules of international are, the more pull it will exert for compliance. That's for sure. Secondly, so when we talk about whether superpowers above law, much depends on the quality of the rules of law itself. Second, compliance with international law to a large extent depends on your domestic institutional capacity. And in that regard, I think China has yet to sort of come, to understand this. A lot of resistance is seen, by outsiders to the sort of compliance with rules of international law. Actually, are caused by this sort of capacity, institutional capacity building problem. Like this human rights, for instance, like this, intellectual property rights, another instance. In this very regard, I wrote a very short, an article a few years ago. Use four parameters to evaluate. One is legitimacy. The other is complementarity. Another one is what else? Anyway. There are several parameters. I mean, to Chinese, the most urgent issue these days is how to sort of push this institutional innovation, institutional capacity building to accommodate international law, the accommodate requirements of the obligations of international law. So this is a big issue.
Thank you, and I think on that note we've gone well over time. So thanks to all our panelists. And thanks to the audience.
Thank you very much.
Thank you.